Welcome, ladies and gentlemen, and children of all ages. Oh, I did that yesterday. You can tell what I secretly dream about being. Anyway, welcome to Talkback, which is brought to you by the first half hour, brought to you by Bitterroot Motors, doing it right for more than 41 years. Also brought to you by Temp-Right Service, called Team Blue, 728-1111, and the Mustard Seed Restaurant. There he is, ladies and gentlemen, in the center ring. That's John King.
I have my top hat on this morning.
You do?
Yeah.
Wow. Okay, cool. So
I've got my dapper gear on.
You're the lion
tuxedo.
tamer?
I don't know if the lion tamer wears a tuxedo.
Well, usually it's the
Ringmaster.
The ringmaster, yeah. Wears the tuxedo.
Yeah.
I thought I was the ringmaster.
I don't know. I think you're the PA guy.
I could be. I'm stuck being the PA guy, even at the circus. Anyway, so what we wanted to do this morning is after yesterday's rather interesting news story that came out regarding it was I think it was in the Missoulian and the Associated Press talking about the mayor and the costs of acquiring Mountain Water up over $3.5 million. I'm like, wow, that's amazing. How did it get so high? And so I wanted to call and find out. So I got a hold of Ginny Miriam, the communications director for the city, and arranged an interview with Mayor Engen about a little after 1 o'clock yesterday afternoon, and so visited with him for a few minutes and asked him about the numbers involved in that story. And so I'll just kind of read you what we got here. It says, Missoula Mayor John Engen taking issue with a report released Friday by the Missoulian regarding the legal and other costs incurred so far in acquiring the Mountain Water Company. The report states legal fees, quote, have hit $3.5 million and will likely head higher, end quote. I asked Mayor Engen about that, and he said the total costs so far, according to the mayor, are far less than what had been forecast.
As of today, we have spent $1.3 million. That, not just attorney's fees, that's engineering, that's expert witnesses, folks who are telling us that this is the right thing to do for a wide variety of reasons. So that's our investment.
And he also said that the city would state its case in Missoula District Court coming up in March.
We will demonstrate to the court that it's more necessary for the city of Missoula to own this monopoly utility than it is for the current owner or any successor in interest to own it.
Now, here's one of the statements that he made that I a little bit take exception to, in that he said he states his case as to why he's so determined for the city to own the Mountain Water Company. Now listen closely to what he says here.
There will be a new owner of Mountain Water Company unless it's the city of Missoula. It will not be a local owner. It will be a corporation that's investor-held, whose only real goal will be to make money.
Okay, so now here's my question. What's wrong with a company that's owned by investors whose main purpose is to make money? I think we call that capitalism, don't we? I mean, that's how many of you out there own stock in a business? If you have a 401k and it's invested in a mutual fund, you are probably invested in dozens or maybe even hundreds of stocks in companies that are owned by people like you and me and everybody else. And if they don't make money, we dump them and find somebody who does. That is capitalism. And I just don't see anything wrong with that. Whether it's Algonquin or whether it's Carlisle or whatever, yes, it may be an out-of-town entity. Yes, it may be a multinational corporation. But just the principle that for some reason it's wrong for a city utility to be owned by a corporation whose business is to make money. Okay. See, here's one of the good things about being owned by a business or a corporation whose business it is to make money. What are they going to do?
Provide a service.
They're going to provide a service. They're going to provide a better service than their competitors, because that's the essence of capitalism, is competition.
But there is no competitor for water service in Missoula.
I know, but
it's kind of a different ballgame.
But what I'm saying is in principle, it is, I think, it's a good thing to have an investment in a company that is making money, doing things responsibly, looking after their shareholders, looking after their employees, looking after basically the business of what they do. I just don't see anything wrong with that. And the mayor has been actually quite consistent in his message that he did not want a company like Carlisle to own a mountain water company, because he says all the money is going to rich fat cats out of Missoula, whatever. Whereas if the money was here in Missoula, if the water company was owned by the city of Missoula, then first of all, would there be any profits? I don't know. See, and that's the question. So what happens to the money that is made over and above expenses? You see, in Mountain Water Company, if it's owned by the city, would it have to? Is there some sort of charter whereby it would be mandated that if there are any excess funds after all the expenses are paid, would there be something in the charter saying it has to go back into infrastructure? It can't just be willy-nilly spent and dumped into the general fund to add to the basic things that the city council wants to do. I don't know what the rules are in that.
I don't know either. So, I would bet that they would go back to the general fund. I think that's what the mayor would like.
Anyway, but he's not here and doesn't want to come on the show, so.
You're welcome anytime, Mary.
We do the best we can. And by the way, if you want to listen to the entire interview, it's there. It's on YouTube, on our website at newstalkkgvo.com.
Well, let me ask you this. We got a call. We got to go to a break.
Okay.
But it seems to me that there's a debate going on between the writer at the Missoulian, I think it's Kyla Spaller, and the Engen team over at City Hall.
Right.
And that debate is over whether or not the city is going to end up holding the bag for all of the legal fees and that are accrued by the Mountain Water Company and Carlisle Group. Right?
Right.
That's the debate, whether or not that will happen.
Now, when I visited with the mayor, and it's part of the interview, the mayor told me that it's not necessarily has been decided yet whether the city would be paying everybody's bills for this condemnation lawsuit. So when he used that $1.3 million number, he said that, he said, he's looking at a spreadsheet right on his computer at his desk, and said, as of today, which was yesterday, it's $1.3 million. And that includes all the legal fees and the engineering costs and the cost of bringing in expert witnesses and all that sort of thing. So far, $1.3 million, which is far less than $3.5 million.
Right. That's because he's not factoring in any foreseen costs.
So we'll see how that works. Okay, we're coming up against a break. Pete, we're going to get to your call here in a moment. If you'll be patient, we'll be right back. And we're back on Talkback. 721-1290 is our number, 1-800-568-5309. I would say thank you to Pete for his patience during that commercial break. Pete, good morning. You're on Talkback. Go ahead.
Good morning. Just a few comments.
Yes, sir.
I think the Missoulian is really being somewhat on key, because if you look at the past, when we tried to condemn the water company, we had to pay all the costs, and that customarily hasn't changed. They would have to appeal as to why it shouldn't be that way. That's additional legal costs. And your comment about the profit of comments from the mayor, the other thing he's not pointing out is, he has in the past, not recently, is that a private company is not exempt from taxation, so they're helping contribute to our tax base in the school system and in the county.
That's another very important fact, absolutely.
Yeah, and he kind of brushes over that, and the few comments he's made, he would make up for it for a while, unquote. And the other one that he's not addressing is that it's not, when you're acquiring a company like that, it's not at any cost. I mean, is he willing to go on the record in advance that our rates will not increase over 10 years, that any profits come on beyond operating expenses and improvements will go into tax relief? Let's see what his real intent is.
Well, I actually have seen an interview or at least read the transcript of an interview between Mountain Water Company attorneys and the mayor, and he was asked the question about whether or not, and I'm calling from memory here, so I'm not going to do this verbatim, but he was asked whether rates would go up, and basically his position, it seems, is that yes, they will go up, but they won't go up as significantly as they would under Mountain Water Company or Carlisle Group or Algonquin.
Even though the private companies have to go through public service review and justification, raise a rate, and the city does not.
And, it's interesting. I asked Mayor Engen about that, about the whole Public Service Commission, the fact that they wouldn't be under the regulation of the Public Service Commission. And he said, in all the major, and his response was, and again, you can hear it for yourself on the website at newstalkkgvo.com, but he said in every major city in Missoula, in Montana, in which the water company is owned by the city, none of those are under the purview of the Public Service Commission, and they seem to be doing okay. So
yeah, none of them had to learn on the fly either. They've been doing it for quite a while. I mean,
well, they had to start somewhere.
But I mean, the other point the mayor makes on this one is that why would you trust a PSC, which most people don't even know who's on that board, that is based out of Helena, with one member over in this representing this region, when you have much more control and much more direct democratic flexibility with your local city council and your mayor.
Well, here's my question:
Yeah,
what do this?
The mayor who really demonstrated how they're keeping our taxes down.
well, but my other question, Pete, and to John and to our rest of our listening audience, is what does the city council, who are an amalgam of people from different walks of life, okay, there's journalists, there's business people, I'm sure there's probably a nurse or a doctor or whatever.
Basically, the only qualifying thing is that you have to have free time.
Well, yeah, because there's a lot of meetings when you belong to the city council, and of course the money is so lucrative. But anyway, what do they know? And for that matter, what does the mayor know about running and policing, if you will, a major water utility?
Well, and as part of the court proceedings, they're supposed to supply an operating plan.
Yeah, and according to John Kappas, whom we had on our show a couple of weeks ago, the city has not brought to them an operating plan yet.
What a surprise!
Anything else, Pete?
Oh, thank you.
Hey, thanks for the call. Appreciate it. 721-1290 or 1-800-568-55.
Saying there's a plan.
Yeah.
Huh?
So anyway, so on and on we go, and the mayor did tell me that there was an attempt to postpone the court date from March 15th to whenever, but he said Judge Karen Townsend quashed that request, and so to the best of his knowledge, on March 15th or somewhere in there in mid-March, the city will go into court. Whoever, all the other groups will come into court and state their cases before a judge, and the judge will say, yes, you can go forward, or no, you can't go forward. And at that point, whatever the costs are, that's what we'll end up having to pay.
No, the thing with the mayor's defense of how much we've spent, it is partially true from what I can see, but it's also partially untrue. And here's the reason why I see it this way. Imagine you go to a gas station and you pay with credit for your gas. You go inside and you see a Laffy Taffy or some kind of candy you want to buy at the counter, okay?
Okay.
You get a stick of jerky, okay, for $1.
Right.
And then you walk outside. Well, how much money did you spend, hon? Well, I spent $1. Well, technically, that's true. You only spent the $1. You put the rest on credit. You put it on a credit card, and you're going to be paying for it later. But it's a foreseen cost. You know you're going to end up paying for it. And the way that these lawsuits work, as was mentioned by our prior caller, if you win the lawsuit, you end up having to pay for the legal costs of the defeated. If you lose the lawsuit, you end up having to pay, as we did in the 80s. It almost always happens that way. I can't even think of a case, and I think the mayor should be pressed to come up with a case in which that wasn't true, to give us an idea of what the foreseen costs are, because I think most reasonable people would foresee this cost as being something that we would need to include. Now, there are going to be debates, and they will haggle over how much of the legal fees the city needs to pay for. But I'll tell you right now, most likely Carlisle Group and Mountain Water Company, they're spending as much as they can on lawyers, knowing that they're in the safe zone, knowing that the city is likely going to have to pick up the costs. And so what's going to happen is then it's going to go back, just like that South Avenue case, and they're going to say, well, we don't need to pay the lawyer for this. We don't want to pay him for this. Then it'll go to court, and it comes back, oh, you do have to pay him for that, and you have to pay him for the added time.
So they go to the Supreme Court.
And then, they're going to keep doing this. And
Back
you know
and
what?
forth.
We're going to keep ending up getting soaked, and lawyers' coffers are going to get filled while these debates go on. It's almost certain to happen.
Well, let's put it this way. Even if Mayor Engen threw up his hands today and said, okay, I've seen the light. We're just going to drop it all. We're done. Forget it. So what happens at that point? We're still on the hook.
Well, you know what happens?
For all
the
that
city of
money.
Missoula continues to drink water like it has been before this lawsuit came.
Right.
But they stop spending money.
Right. Okay. We're going to take a little break. Come right back. Don't forget, Rob Natelson's going to be joining us at 8:30. It's our regularly scheduled first Tuesday of the month, and a great way to start the brand new year is with Rob Natelson from the Independence Institute. So, Greg, we're going to get your call right after this quick timeout, so please stay with us. A whole brand new year on Talkback. 721-1290 is our number, 1-800-568-5309. You can also make your opinions known on our Facebook page.
You were real fancy with 09.
09.
And then you...
Facebook.
It will sound like Prince Albert.
Thank
He's
you.
in a spot of trouble right now.
Do you have Prince Albert in a can? Let him out. He's suffocating in there. All right, that's one of the oldest jokes in the world. Greg, good morning. You're on Talkback. Hi.
Hey, good morning. Happy New Year, guys.
And the same to you, sir. What's on your mind?
Thank you. Hey, what are we buying from what does the city of Missoula want to buy from Mountain Water?
They want to buy basically the utility, if you will, the monopoly utility of providing water to the city of Missoula, which Mayor Engen has said over and over and over again that he does not want. And the city council, I guess, agrees with him that they do not want that utility that provides such an essential service in the hands of an out-of-state multinational corporation that, quote, doesn't care about Missoula.
Oops, but that's not what we're buying. That's what we're afraid of. I don't know what we're buying.
Well, you're buying the infrastructure and you're buying the management of the water system.
Are we buying a 62 Chevy or are we buying a 2014 Chevy? See, we haven't even done our
Due diligence.
due diligence, thank you, on what we're buying. I mean, there was discussion about how the water system, the piping is, underground pipes are failing, there's a lot of leakage. What are we buying? I mean, that analysis, that due diligence analysis, I haven't seen anything on it, and I find it fascinating and pretty instructive, actually, that I'm a business owner. As a business owner, if I'm going to buy something, I want to know what I'm buying. What kind of return on investment am I going to get? What kind of costs am I going to have to own this asset? And I have yet to see what kind of costs are involved in owning this asset. All I hear about is the boogeyman. And, that's just completely 180 degrees.
So, Greg, do I hear you saying that the whole Carlisle multinational group is kind of a straw man argument?
It is a complete straw man. It's a non-topic. If you want to buy this asset, tell us what you're buying. Tell us how it's going to enrich the people of Missoula, and tell us what it's going to cost to manage that thing. And have you guys seen anything on that?
Well, I mean, what I keep getting from the mayor is kind of an ideological absolutism that seems to believe that private company ownership bad, city ownership good.
Great. So we'll buy a $41 million park bond.
Well, and I think that absolutism goes to play in the way that he talks about the cost of it. Well, how much is it worth? There's no ceiling. There's no ceiling when it's an absolute value.
Well, as a matter of fact, in my conversation with the mayor, he said that during the court case, which is coming up in March, so once they get together and everybody states their case, he says at that point there will be a valuation part of the lawsuit where the actual
so
value
we don't get to see what's in the bill until we pass the bill.
Or at least until we're in the middle of our of the court date. Yeah.
I mean, it is stunning to me that we are approaching something of this magnitude without first doing our due diligence and looking at the cost analysis of it. The idea that first we're going to condemn it, then we're going to figure out what it costs to own it, it's just completely out of phase. And it's proof that government has no business, well, they have no business being in business. And I guess that's I just like to turn this around a little bit, guys. And I'm just stunned that this is the way it's being approached. And it shows me the complete lack of understanding of what a P&L statement is and operating costs are that the city takes to things.
Well, very thoughtful comments, Greg. Thanks.
Thank you. You guys have a great day.
Appreciate the call, and Happy New Year to you. Mike, you're on Talkback. Hi.
Yeah, this is one thing I've always wondered about this, going after the water company through eminent domain. And I've had quite understand that eminent domain is if you need a road or for the general population, you can condemn something through eminent domain. But the place is already in existence. They're already getting the goods and services provided. So how do you get them into court on eminent domain? If you know somebody around, I'd sure like to hear the answer to that one, because it goes against even our Constitution. How can you sue somebody that's providing a service? You could, if they weren't providing a service, sue everybody. You can get a right of way for the water lines through eminent domain. But how do you get them into court on eminent domain? Because it doesn't make any sense.
Well, I wish I could say that it doesn't make any sense, but in other cases around the country, eminent domain has been used to do some pretty stupid, apparently unconstitutional things.
I know that.
And so I don't distrust the ability of the courts to find a way to weasel in that eminent domain should apply in this case. It's possible.
It doesn't say, according to what I think I read that in the Constitution, the clause about eminent domain, and I don't believe it says there, if you've already got a service, say you got your lights, your power lines on, so another guy wants to buy your power line and say, well, I'll give you the same thing, but I'm going to sue you through eminent domain. This doesn't make absolutely any sense. The whole damn thing ought to be thrown out, period. I don't think anybody's read anything on this.
Well, courts have come up with a bunch of different ways. Well, I got to let you go, but they have different tests that they do to see if eminent domain should apply, and one of those is how the company performs at its duties.
Okay, well, let's get let's get Candy on real quick. Candy, we got about less than a minute before we have to switch over to Rob Natelson. Go ahead.
Yes, okay. Last night, Mayor Engen alluded to the fact that this investment that we are going to be making already has structural problems. So we're not only, that's what he said, that the study found that there were problems and they weren't being honest about the problems. And so now we're buying an asset that's going to be costing us money right off the bat to rebuild the infrastructure. So I don't understand. That's not a real good investment in my eyes. Thanks
for your call. Thanks for the call. Okay, let's try to get one more call in before we shift gears. Ted, real quickly, what do you got for us?
Okay, we've seen the Democrats target you for your conservative values over and over again with the IRS and whatever it may be. What makes you think that the Democrats in Missoula will not target you for your water rights because of your conservative values? If you think not, then you're naive and you're vulnerable to an attack. Thank you. That's all I have to say.
Okay, Ted, thanks. I did ask that question, by the way. I addressed that, the whole annexation argument.
Oh, okay.
Because one of our listeners asked me to ask the guy about that. So would the city use their ownership of the water company to force individual businesses or whatever to be annexed into the city if you want to get mountain water, right? Uh-huh. And he said, they could do that. They would have the power to do that, but it wouldn't make a whole lot of fiscal sense because there's a lot of steps that go into annexation. Uh-huh. It isn't just hooking up to the sewer or hooking up to the water company. There's a lot more that goes into that. So it would not fiscally make any sense to try to do that to individual homeowners or an individual small business here or there. Just the same as it wouldn't make sense to do to try to annex a single home into the city just because they wanted to be on the sewer. So that was his explanation.
So he said they could do it.
They could
but
do
they
it.
wouldn't do it.
Yes.
One at a time. They do it all carte blanche.
Well, they would have to wait until perhaps an entire subdivision wanted to hook up, and so that would be a point to bring them into the city. So there you go.
I think that the ball is still out there that could happen.
Well, we're going to take a break. Rob Natelson is waiting on the phone. He is, of course, with the Independence Institute in Denver, Colorado. We're going to talk the U.S. Constitution and the Commerce Clause.
That's right.
For the first few minutes, we'll be right back. I feel like I'm watching an episode of Airplane or something. 721-1290, 1-800-568-5309. If you could see John and I both futilely attempting to...
Just don't ask me to attempt to talk jive.
Shake
not
our,
very good at
our collective booties or whatever they call them. Anyway, but that's okay. Rob Natelson is joining us in the studio. He will bring some gravitas to our booty shaking here.
That's right. Rob Natelson is one of the nation's most influential legal scholars. And when I say that, I'm not just blowing hot air.
There you go.
This guy is a guy referenced by the Supreme Court on many occasions. He's also worked here in the city of Missoula, was a teacher at the University of Montana. Now he works at the Independence Institute. Professor.
There you go.
And now he works at the Independent Institute in Colorado, where he writes a regular blog. I'll link to that on our website. And he does a lot of deep history work when it comes to the Constitution. And one of the things I really wanted to do a while ago, we missed it last session with Rob, but was kind of dive into particular topics that Rob has spent a lot of his life studying and researching. And today's topic is especially interesting. I believe Rob has even traveled to England to research this particular topic. And it is the Commerce Clause. A little couple sentences in, or not even two, I don't think. A snippet of the Constitution that has been used to grow government
well, you bet.
Beyond, I believe, original intent. But Rob will be able to school us on what's going on here. So welcome to the show this morning, Rob.
It's good to be back, guys.
A Happy New Year to you, sir.
And it would take some effort to put some gravitas into this show, I'll tell you.
You got that right. With the emphasis on the os in gravitas. But anyway, let's talk about the Commerce Clause. Now, Rob, for folks who are just joining in and perhaps haven't had a chance to read your book or to read the Constitution itself, perhaps since high school, would you mind sharing with us what exactly is the Commerce Clause? How does it read?
Sure. It's a part of the Constitution. You can find it in Article 1, Section 8, and it's the third clause in Section 8. And it says that Congress shall have power, and I'm quoting now, Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes. And so here it's granting to Congress the power to regulate commerce with foreign nations, with other countries, imports, exports, that sort of thing. And also commerce that moves from state to state. And then commerce which people have with the Indian tribes, buying and selling of goods across reservations and so forth. I should also mention that it's probably a little bit more complete to talk about the Commerce Power rather than the Commerce Clause, because the Commerce Clause works together with another part of the Constitution called the Necessary and Proper Clause, which gives Congress authority, or at least recognizes authority in Congress to make all laws which shall be necessary and proper for carrying into execution the Commerce Clause. So much of what Congress does under its Commerce Power actually is carried out under the Necessary and Proper Clause rather than the Commerce Clause itself.
So I think a good starting point is to go to the way back, right when this clause or this power came into existence. What did the word commerce mean to the founders?
Well, that's one of the things I spent my time in England investigating, because let me back up just a second. One of the things I do for a living is I go to parts of the Constitution where there hasn't been much writing, or the writing hasn't been very good, and try to get to the root of what that phrase in the Constitution really means. And I publish my findings, whether I like the results or not, and whether they match my preconceived notions or not. In fact, I've had to change my views on many occasions. There had been quite a bit of writing on the Commerce Clause, but it hadn't been of very good quality for the most part. So what I did is I looked first at every single case that had been decided from the 1500s right up to the date the Constitution was ratified, both in America and in Britain, to see how the term commerce was used. And then I also looked in as many legal treatises as I could get a hold of, and other kinds of treatises, books on commerce, for example, from the 18th century, to find out what commerce meant. And what I found is that commerce was not as narrow as some conservatives or libertarians claim, but it was certainly not as broad as liberals or progressives claim. Commerce was trade. I mean, everybody acknowledges that. But it was a little bit more than that. It also included a lot of things that were related to trade. For example, control of navigation, control of shipping. It included control of cargo insurance, where you take out insurance on a cargo that you put on a ship. It included control of transportation to a significant degree, also commercial finance. But it did not include control over other parts of the economy like manufacturing or agriculture or mining and so forth.
Now, Rob, if I remember correctly, one of the beginnings of the expansion of the commerce and necessary and proper clauses was back during the Depression, during the Roosevelt administration, when some farmers, I think, refused to sell their crops at a price that others were selling. I believe it was something to do with that. And so the federal government came in and said they're going to use the Constitution to force them to fit their commerce into a certain price structure. Is that accurate or not?
Well, you're thinking of a case called Wickard versus Filburn, which was decided in 1942.
Okay.
And that was part of the progress you're talking about, or part of the change you're talking about. Previous to that time, the court had really, or previous to about 1937, the court had tried to chart a course that was generally consistent with the wording and intent behind the Constitution. Congress could regulate trade among the states. It could not generally regulate trade inside states, with a few exceptions, but it could regulate trade among the states, trade with foreign nations. It could regulate navigation and other things traditionally associated with trade. But that they can do all those things under the Commerce Clause. The Necessary and Proper Clause was supposed to give Congress authority to just handle certain subsidiary matters that we call incidental. For example, Congress could say, if you're going to ship your goods in interstate commerce, you've got to have them labeled correctly. So the labeling would be a command under the Necessary and Proper Clause. But under the pressure of the Great Depression, where Congress wanted to and the President wanted to assume general control over the economy, the court first resisted, but later on gave in to the demands of the politicians, and started to hold that under the Necessary and Proper Clause, Congress could also regulate not just commerce, and not just those things traditionally associated with commerce, but also mining, manufacturing, insurance, and, as you mentioned, farming.
Tell you what, we're up against a break, Rob, so we're going to continue with this discussion about the Commerce Clause after this quick time out, and we have two lines open at 721-1290. We'll continue. This is very educational. I'm enjoying it. We'll be right back with more with Rob Natelson in a moment. You got Talkback at 9:15. Thanks for joining us here on a Talkback this morning, 721-1290. Joining us on the telephone, Rob Natelson with the Independence Institute, right in the middle of a primer, if you will, on the Commerce and the Necessary and Proper Clause.
That's right. We talked a little bit about the Commerce Clause, and Rob was just kind of expounding about the founders' view of that, and Peter threw into the mix how we started to interpret it after the New Deal.
Right.
And I also wanted to kind of go back to the Necessary and Proper Clause, because that particular clause, combined with the Commerce Clause, kind of give us the commerce power. And it seems to me that a modern interpretation of the Necessary and Proper Clause almost is anything that the Congress finds necessary or proper to do. They've almost granted themselves new powers through this particular phrase. And I wanted to get your comments about what the founders used this phrase for and how it was intended to work.
Well, I'm not sure what you just said is true, John. It is true that when the court applies the Necessary and Proper Clause to economic matters, it tends to be pretty much anything goes. But when the court applies the Necessary and Proper Clause to other matters, to other parts of the Constitution, it tends to adopt a much more restricted view and one much more in keeping with the founders' view. Also, in the Obamacare case, you remember one of the arguments was that the necessary and proper clause permitted Congress to adopt this penalty for not buying insurance. And Chief Justice Roberts, in his opinion for the court, considered whether the necessary and proper clause authorized that. And he said it did not. And he went ahead and he expounded on the necessary and proper clause in a way that leads us to believe that he was probably following our friend to the court brief, and said that the necessary and proper clause is really not a grant of power. All it is really is a statement of intent or a statement of understanding. And that's really what the founders would have said. They would have said, look, when the people gave to Congress the power to regulate commerce, you got to interpret that in a reasonable way. You can't be ultra strict in the way you interpret it. So think of the example I gave you a minute ago where Congress could say, in your manufacturing process, you must label goods if you want to send them into interstate commerce. That's certainly a reasonable interpretation of the commerce power. And so all the necessary and proper clause was designed to do was to make it clear that we shouldn't be too nitpicky about Congress's power. It was never designed to grant to Congress entire control over the economy, which is how it's been used.
I wanted to ask you also. You started with an example that I thought was really interesting about how government kind of expanded power into agriculture in the New Deal. Has it grown in power through the Commerce Clause since the New Deal era?
Yes. Yeah, the most notable example is in the area of civil rights and in the area of crime, criminal laws. In the 1960s, 1964, the Civil Rights Act of 64 was passed. And that was passed under the Commerce Clause. And what that did is it forbade discrimination based on race in private accommodations. Now, let me just say offhand, I would say right away, I have no brief for discrimination based on race, and would have supported a constitutional amendment to deal with that. But instead, the court used a very exaggerated version of the Commerce Clause to uphold that law. In addition to that, in the 70s, 80s, 90s, often, interestingly enough, under Republican presidents or Republican Congresses, Congress started to move very heavily into criminal law, which was, except in a few areas, traditionally the preserve of the states. And again, the usual justification for federal criminal statutes is the Commerce Clause. There's a case in which the Congress was regulating, routine local loan sharking. I mean, the kind of thing that's an in-state activity that traditionally would be handled by state criminal law, and yet the court upheld that as a regulation of interstate commerce, upheld the law as a regulation of interstate commerce. However, the court has drawn some lines. In a few instances, the court has said that the states have gone too far, and even under this very broad interpretation of the necessary and proper clause, we're not going to allow Congress to just do anything.
Okay, we're up against a break, so go ahead, John.
Oh, no, that's okay. Well, I was going to ask if our federal drug laws are also under that Commerce Clause, if that's the argument used to expand those powers.
And not only that, but look what's happened with when medical marijuana was made legal in Montana. Everything was fine for a little while until all those shops got established and the money started flowing in, and then boom, the federal government quite literally lowered the boom. So that the whole industry has never recovered. So we're going to come right back and visit more with Rob Natelson right after this. This is Talkback. 721-1290 is our number. Just a few minutes left in this segment. Joining us once again, of course, from Denver, Colorado, the Independence Institute, Rob Natelson, former professor of law at the University of Montana. Go ahead. Now, John, to restate your question.
Yeah, I was wondering if our federal drug laws were using the Commerce Clause to kind of get their roots into the system here. That's
right. That's exactly the justification for them. There was a case in 2005 called Gonzalez versus Raich, in which arose in California, which had a medical marijuana law. That is to say, they permitted the use of marijuana for medicinal purposes. And a woman named Mrs. Raich was raising marijuana plants in her window box. And the Supreme Court held that under the Commerce Power, in particular under the Necessary and Proper Clause, that the federal government could even reach Mrs. Raish's window box and force her to stop raising marijuana plants there.
That sounds vaguely familiar to what happened in Montana.
Well, yeah, but it raises the question. Since that time, as I said in 2012, you've got this statement by Chief Justice Roberts for the court in the Obamacare case, in the part where he said that the Necessary and Proper Clause does not justify the penalty for not buying insurance. And he seemed to be signaling a major retreat. He seemed to be saying, "Hey, look, we're going to apply the Necessary and Proper Clause more narrowly from now on." So it would be interesting to know if the court would reach a result different today than it reached in the Gonzalez versus Raich case back in 2005.
That's yet to be seen, I assume. Are there any court cases pending that might lead to that decision?
Well, interestingly, there's the Montana firearms litigation. Now, I'm not familiar with the status of that litigation right now, and maybe a caller who is familiar could call and update it. But under the leadership of Gary Marbut of the Montana Shooting Sports Association, a proposed law was drafted, in which Montana claims control over the domestic, that is the in-state manufacture of firearms. And the Montana legislature adopted the law. It was signed, I believe, by Governor Schweitzer, and the litigation began. And my understanding is that, as fully expected, the lower courts, lower federal courts, have held that that law cannot stand in the face of the federal commerce power, that federal control over firearms and through the commerce power takes priority over the states. But if the case should go to the Supreme Court, and again, I don't know what the status of it is, it would be interesting to see if the Supreme Court makes some modifications in its doctrine.
We are going to have to go to a break here. If you want to find out more about the Constitution, pick up Rob's book, The Original Constitution, What It Actually Said and Meant. It's on its third printing now with new information from I believe he has a new article on the Originations Clause and other topics, including the Commerce Clause or Commerce Powers. So we'll be back with Rob. We're going to open up the floor. You can ask questions on any other topic you want. We got lots in the armory here to discuss.
And we might even throw in some charter school information there as well, so which we don't have in Montana yet. So anyway, we're going to take a quick break. We'll be right back, so stay with us. Okay, welcome back. Well, this is Talk Back. Hour number 2 is underway. John King's over there. I'm Peter Christian, joining us on the telephone this morning all the way from Denver, Colorado. And the Independence Institute is basically he's the man who does all the research on the Constitution, who's actually, how many times have you visited Great Britain and Europe to look into these various facts and figures there, Rob?
Well, I haven't really spent any time doing research in Europe, unless you consider Great Britain Europe. I don't know the answer to that question offhand. Half a dozen, maybe. Some of it, for example, there was a 4-month stretch in 2005 in which virtually all my time was spent on research. In 2011, I went back to do some supplemental research at Oxford, but I didn't go back only for that purpose. So so it's kind of hard to come up with an estimate. By the way, I should mention that I'm actually on the phone today from Lakewood, Colorado, which is a very nice city, sandwiched in between Denver and the mountains. So you can actually walk up a mountain of sorts right out the front door here.
Fantastic. Now, one question before we have a caller who wants to visit with you. One question I wanted to ask you about your research in Great Britain. Where did you go to find the information, whereby you find these nuggets of information of what the founders and the writers of the Constitution originally said and meant? Where did you actually find these documents?
That's a great question. One answer to that, and probably the most important answer, is the law library at the University of Oxford, because they have a magnificent 18th century collection, meaning they have the kinds of books that our founders read. And then there's also a library, the main library at Oxford, called the Bodleian Library, which which contained a lot of the literary works that they had. Remember, this is in the days before Google Books, but in many ways their collection is even more thorough than Google Books. And then one of the most interesting places was in London. In London, there are institutions called the Inns of Court, and one of them has the unusual name of the Middle Temple. And a substantial number of our founders actually got their legal education at the Middle Temple. So people like Edward Rutledge and John Dickinson were educated there. And one of the big thrills I had was actually being in the library and being brought these books that could have been the very books out of which someone like John Dickinson studied his law.
Wow. Interesting stuff.
All right, let's get to the phone. We do have, let's see, I want to make sure I get this
It's
right.
Frank.
It's, okay.
By the way, I should mention,
Yes.
also, I've also spent a little time at the University of St. Andrews in Scotland, where one of our founders, James Wilson, was educated. And I actually got a hold of they gave me Wilson's library records. So you could actually see what he took out from the library
Wow.
as a student, what he was interested in. And John, you might be curious to know the thing he seemed to like the most was Roman history.
Really?
Yeah.
Interesting.
And as a matter of fact, that record is so old, it was stored on a floppy disk. So that's how old it was. All right. Let's get Frank on the line. Frank, you're on with Rob Natelson. Go ahead, sir.
Professor Natelson, Obama has nominated a candidate to be the new Attorney General. The new chairman of the Senate Judiciary Committee is a Republican. What would happen if that new chairman decided, for whatever reason, he did not like the new candidate and was not going to hold any hearings? What could the president do?
Well, that's a good question. The president could withdraw the nomination. He could make a different nomination. He could wait until the Senate was out of session, and he could make a recess appointment that would last until the end of the next Senate session. Or he could simply go ahead and allow the department to be administered by the career people who are there. You know, when you don't have an attorney general, things don't stop. The folks who work there just continue to carry on. And so those would be three of his options.
You may recall, Mr. Natelson, not too long ago, a candidate was nominated to be the new Attorney General, and the Republican chairman of the committee said no, and that gentleman had to go down the road. I think his name was William Wells of Massachusetts. He was turned down, and no hearings were ever held, and life went on without it.
All right.
Well, that's right. It does go on.
Thank you, Frank.
Congressional committees sitting on nominations is pretty common.
All right. Well, one of the things I wanted to talk to is the 800th anniversary of a very important document. We're going to have a break here in just a few seconds, but my name, John King, is kind of familiar to another name, King John. Not very much liked by the English monarchy, but famous for signing.
Just as our John King is not very well liked by the current monarchy in Missoula. I mean, now you want to talk about drawing some parallels. There you go.
I don't think that the English monarchs call King John a pipsqueak, though this John King often, or has at least been called that. Anyway, a little document called the Magna Carta,
yes,
or the Great Charter. I wanted to get Rob's take on this particular document when we come back from the break, which many consider one of the most important pieces of paper in human history.
Well, absolutely, and upon which many of our most important documents are based, and some of the principles there. And we'll be right back. Rob Natelson joining us. We do have two lines open at 721-1290, as Frank found out a minute ago, 721-1290, 1-800-568-5309. We will be right back in just a moment. Okay. Enough already. 721-1290. Thank heavens we don't have video in here. All right, let's get Rob Natelson back on the telephone with us this morning. Rob, of course, joining us from not necessarily Lakewood, Colorado. Is that right?
Lakewood today, yes.
Yes, all right. There you go.
Which we learned is not near a lake or woods. It's between Denver and the mountains.
Exactly.
No, actually, the story is I was curious about the name of the origin of the name Lakewood, because while there are woods here and there are lakes, they're mostly artificial. The woods are planted and the lakes are reservoirs. And so I went to the Lakewood Heritage Center, which is run by the city, and I said, how did Lakewood get its name? And the answer was the area was settled by some people from Lakewood, New Jersey.
Why not?
Oh, why not? All right.
I guess that's the answer for being homesick. You just renamed the city for where you were from.
I guess so.
Yeah. Now, Rob, obviously you're a constitutional scholar. You have an article up on your blog at the Independence Institute, which, by the way, if you want to go there, is i2i.org.
Constitution.i2i.org.
And the topic of your post on the Magna Carta is the greatest constitutional document of all. And I'd like to give you an opportunity to defend that statement and posit why you think it's the greatest of all.
Well, it seems to me that if you're going to choose the greatest constitutional document of all time, you've got three choices. You can choose the U.S. Constitution, you can choose the Declaration of Independence, which was a kind of constitutional document, or you can choose Magna Carta. And while I would put the U.S. Constitution and the Declaration of Independence at close second, I decided that, in my view, that probably Magna Carta had the greatest influence for good. Over the period of many centuries. Well, one is the fact that it's been around for so long. But what it was King John was he was not an incapable fellow, but he was ruthless and he was utterly untrustworthy. And he was determined to rule like an autocrat. And he fought with everybody. He fought with his barons and he fought with the church. And he liked to fight, I guess. And so finally, the barons and the churchmen said, we've got to rein this guy in. So they raised an army, and they stood him down. And at a meadow on the Thames River is the river that goes through London, a meadow at the Thames River called Runnymede, in the year 1215, they forced him to sign this document. And what the document did, what Magna Carta did, is it acknowledged certain rights that subjects have. Two things about the document are extraordinary. One is that it is a medieval charter, but it's not like other medieval charters because it doesn't just recognize the rights of the barons who extorted it. It also recognizes the rights of the church, the rights of all freemen, some rights even of unfree people, rights of women. The list goes on. And secondly, the document has had enormous influence through the years, and both the British Constitution and our Constitution take their inspiration or their terms to a considerable extent from Magna Carta.
Now, you've been able to kind of expound on the history of the term Lakewood. I want to know if you could do similar justice to the term Magna Carta. Did they know it was a great charter at the time? Why did it get that name? What's the background there?
Actually, no, they didn't. I mean, there might have been some people who knew.
Well, you know that King John didn't name it.
No, he didn't name it that, and he soon repudiated it. Now he died shortly thereafter, and it was reaffirmed by his successors. But no, I mean, it was called the Magna Carta, or Great Charter, to distinguish it from another charter that was entered into just a few years later called the Carta Forestae, the Charter of the Forest. And that had to do basically with royal lands. And so the Royal Lands Charter, while it was very important, was considered lesser than the Great Charter. But after a few centuries had passed, people started to think of this term Magna, or great, in not in its original sense, but in the sense that this was a truly great document, which it absolutely was.
Interesting. So can you explain how it's incorporated into the U.S. Constitution? What
Sorry,
elements?
I couldn't hear you.
What elements did we take from the Magna Carta?
What elements did we take?
Yeah, to put into our own Constitution.
Well, where to start.
Yeah.
One would be the concept of due process of law, okay? The idea of due process of law is if the government doesn't like you, they can't just go after you for any reason that they make up. The basic idea of due process of law is that they've got to follow the established procedures, and they've got to follow the established rules if they want to prosecute you for something. That's the core of due process. Now, somebody who knows a lot of constitutional law may call up and say, hey, due process means more than that today, and the Supreme Court has declared that it means more than that today, and that's true. But the core meaning is basically the government can't make up the rules as it goes along. And that principle dates back to Magna Carta. Another example is what you folks were talking about just before I came on, and that is the issue of eminent domain. The requirement in the Fifth Amendment that if the government takes your property, they have to give just compensation. You can trace that back to Magna Carta as well. The jury trial. Scholars argue as how much the concept of the jury trial owes to Magna Carta, but it's pretty clear it owes something. And it's pretty clear that defenders of the jury trial over the years often resorted to Magna Carta for their arguments. And then something we were talking about earlier, the Commerce Clause.
Mm-hmm.
Some of the content of the Commerce Clause, like the federal government's control over navigable streams, that also can be traced back to Magna Carta. So those are just some examples in our own Constitution. They're not the only ones.
We're up against a break, and I think we have John on the line, not King John, but another John that wants to visit with you. But one question, Rob, if you wouldn't mind answering when we get back. I'm just using my everyman imagination to try to imagine what it was like, or what it took, if you will, the amount of chutzpah it took for a bunch of ordinary people to come up with this list of rules and present it to the king and say, this is what we want, and you are going to sign it.
Well, they weren't really ordinary people.
Well, you know what I mean.
Dukes with armies.
Well, you know what I mean. I mean, these were people who were not necessarily royalty. Anyway, because it just seemed to me to break new ground in human rights that perhaps had not been seen perhaps since the time of Hammurabi. Anyway, we're going to come right back with more of Talk Back, continue to talk about it. John and Eric will get you guys on right after this quick timeout. This is Talk Back, 721-1290, a special day, of course, always the first Tuesday of the month when Rob Natelson joins us from the Independence Institute. Now, Rob, I made a statement talking about the Magna Carta and the amount of courage that it took to bring this list to the. Of course, obviously the king had been defeated in battle. I understand that, but the amount of imagination and forethought it took to be able to put down their ideas in writing as to this is what the people of your country want. And can you comment on that at all, or
Sure.
I'm sure that's nothing new for the time, but considering the type of system they lived under, it had to be groundbreaking.
Well, it was a feudal system, and it was feudalism was often administered by bargains between the king and the barons who served under the king. And so it wasn't at all unusual for barons to insist that the king change the terms or honor the terms of an existing contract. What happened in this instance, though, was that the barons were led by a man you've probably never heard of, but is one of the extraordinary individuals in history, and his name was Stephen Langdon. Stephen Langdon was an Englishman who served for many years as a professor at the University of Paris. He was also a clergyman. Stephen Langdon was the guy who divided the books in the Bible into chapters. In other words, we talk today about chapter 3 in the book of Genesis. Those chapters, that's the division made by Stephen Langdon when he was at the University of Paris. He became, over the fierce objections of King John, the Pope appointed him to be Archbishop of Canterbury, and he moved back to England. And John's fears were realized because Stephen Langdon became involved in the resistance to King John. And so when they negotiated Magna Carta, we believe, historians believe, that it was Langdon who insisted that these unusually broad and liberal terms be included in the document. There's one term, for example, which is really extraordinary. It says that just as King John recognizes that the barons have certain rights, so also the barons agree to recognize those same rights in their own vassals.
Wow.
Now, their own vassals weren't even at the negotiating table, but that's one of the terms of Magna Carta. The barons voluntarily agreed that whatever benefit they got from Magna Carta, they would pass on to the people below them. And that kind of vision, we believe, was the result of Stephen Langdon's leadership.
Very interesting stuff. All right, we've got a caller, John. He has a constitutional question for you. Apparently, John has taught the Constitution for AP classes, so maybe you can enlighten him. So,
Great.
John, go ahead.
Hey, John.
Hi, John.
Oh, thank you, and good morning to everybody there. And I am, as you said, I'm not King John. I'll settle for Colonel John. And the question I had is, in my experience teaching advanced placement government and history, and I spent about 5 times what other people did on the Constitution because I thought it was important. One of the questions I got frequently, and these were bright kids, is the phrase "the general welfare" out of the preamble. Is that a kind of an overworked excuse to do just about anything that the government wants to do? And I was just curious to see your take on that the meaning and the import of that general welfare clause.
That's a great question. I'll answer it, but first I want to refer you to an article I've written that'll give you a better or more thorough treatment. If you go to my website, constitution.i2i.org, and you go to the page that says Articles and Books by Rob Natelson, and you sort of scroll down, you'll find an article called The General Welfare Clause and the Public Trust. And it actually discusses the idea behind the General Welfare Clause in detail. The term general welfare appeared in the Articles of Confederation, and it also appears in 2 places in the Constitution. It appears in the preamble, as you pointed out. It also appears in Article 1, Section 8, Clause 1, where it says that essentially Congress can impose taxes, impose excises for the general welfare. What the general welfare here means is the welfare of the country as a whole, as opposed to the welfare of individual parts of the country. In other words, a state would serve the welfare of the citizens of the state. The general welfare is the welfare of the country as a whole. Now, in the preamble, the term is a statement of intent. It doesn't have any legal force. In Article 1, Section 8, Clause 1, it's actually, part of the Constitution, the substantive part of the Constitution itself. And what it originally meant was that Congress could, it was a limitation on the tax power. Congress could tax in order to store up money to serve the general welfare, but they couldn't serve, for example, the special interests, or they couldn't serve just localities of the country. So, for example, in 1796, there was a big fire in Savannah, Georgia, and the citizens of Savannah came to Congress and asked for a bailout, and Congress said essentially, no, we can't give you a bailout. That's the problem. That's a local problem. It's a problem of Savannah. It's a problem of Georgia. We can only spend money for general welfare purposes. And so that's what the original meaning of the clause is. Now, during the New Deal, the clause was, I can't say reinterpreted because I don't think it was fairly interpreted, but the Supreme Court changed its doctrine, and the Supreme Court said from now on, what the General Welfare Clause means is that Congress can spend any money it wants to for the general welfare. It can't do anything for the general welfare. It can't pass regulations for the general welfare, but it can spend money on anything it wants to for the general welfare. And so that's why you have these huge departments like the Department of Health and Human Services that spend money on things that have nothing to do with the enumerated powers of Congress, because the Supreme Court lets them do it, saying that Congress can spend money on anything it wants to for the general welfare.
Hey, by the way, John, I posted that link to the website that Rob Natelson was referring to in his work on the General Welfare Clause and Public Trust on our Facebook page if you can't remember the path to get there. I had a question for you, too. Earlier, Rob, in our conversation, you had mentioned when it came to the Necessary and Proper Clause that when it came to fiscal issues, that they had a lot more powers than in other realms of governance. And I wondered if that Necessary and Proper Clause growth of power kind of combines with this General Welfare Clause growth in power.
there are 5 clauses in the Constitution that are really the basis of the mega state, or I call it the monster state. And one of them is the Commerce Clause, one's the Necessary and Proper Clause, and one is that General Welfare Clause in the larger taxing provision. The court does apply the Necessary and Proper Clause to the spending provisions too, and it does so fairly generously, but not quite as generously as it does with the Commerce Power. Again, for those folks who might have tuned in, the Necessary and Proper Clause wasn't actually supposed to give any power. It was just supposed to explain that you don't read Congress's power too narrowly, but it's been combined with the Commerce Clause to allow Congress to essentially take over regulation of the entire economy. It's been combined with the General Welfare Clause to allow Congress to do a fair amount of spending that they're really probably not supposed to do. But generally speaking, in other areas, the General Welfare Clause has been interpreted more strictly.
Tell you what, Rob, one quick question before we take a break. Is there any way...
I'm sorry, I should say the Necessary and Proper Clause has been interpreted more strictly. Sorry about that.
Okay. Is there any way, just in 30 seconds or less, either yes or no, I guess, is there any way of walking that back towards the original intent as opposed to, or is the corral is open, the horses have escaped, there's no getting them back now?
Realistically, I think probably there are only 2 ways, one of which has been tried for years and the other which has not been tried. The one's been tried for years is by appointing to the Supreme Court, justices who honor the original meaning of the Constitution, which is, actually just part of the rule of law. The other, and that's had indifferent success. The other, which has not been tried, is an Article 5 convention, a convention for proposing amendments. That method has been used before to rein in agencies of the federal government. The amendment power has been used before to rein in agencies of the federal government, but the convention for proposing amendments has not been used, and as you know, we've talked about it before, there's a lot of interest in using it for that purpose.
Okay, before we're up against a break, Eric and Paul, we'll get both of you on. Rob Natelson joining us. All of our lines are full, and you can also make your comments known on our Facebook page. We'll be right back. Oh, yeah. 721-1290 is the number for Talkback. And, of course, it's one of our favorite times of the month, the first Tuesday. That's when we get Rob Natelson on the line from the Independence Institute. And everybody wants to talk to Rob this morning, so let's get right back to the phones and say good morning to Eric. Eric, good morning. You're on with Rob.
Good morning.
Hi, Eric.
Hi. I believe that my rights precede all human documents. That I had rights before the Declaration of Independence, before the Constitution, before the Magna Carta, or any other document. And I believe that all human institutions should acknowledge, which I believe the Declaration of Independence does, that our rights come from our Creator, they're individual rights, and that governments cannot take them away arbitrarily. And most of our founders, or many of them, had a Christian worldview, and I'd like to hear you discuss that.
All right, Eric, thanks.
Thanks for your call. So go ahead, Rob.
Okay, what Eric is doing is he's explaining that he subscribes to what could be called a Lockean view of natural rights. That is to say, the view that was popularized by John Locke, although it's not by any means limited to him. And he's right. I think the founders generally subscribe to that idea that rights come before government. Now, at the time of Magna Carta, that wasn't necessarily recognized. I mean, Magna Carta is written in the form of King John granting rights to his subjects. Of course, they really, they forced them to grant them, but it's written in those terms. And the Constitution is what we call a document of positive law. It doesn't resort to the natural law theory as the Declaration does. Natural rights overlaps the Christian view, but it's not quite the same. There have been certainly Christians who don't really subscribe to the full natural rights theory, and there are people who are not Christians who do subscribe to the natural rights theory. But he's right in that nearly all the founders were Christians. You might have heard the story that the founders were disproportionately deists. That's actually not really true. They were virtually all Christians, and they naturally were very strongly influenced by the Judeo-Christian heritage.
Okay, let's get back to the phone. And Paul, you are on with Rob Natelson. Go ahead, sir.
Yes, good morning, Rob.
Good morning, Paul.
Glad to hear you're still fighting the good fight, even if it's not in Missoula anymore.
It's all over the country these days, Paul.
Okay, I was hearing you talk about all the good rights that were given by the Constitution and Bill of Rights by the retired law enforcement officer of over 25 years. I've noticed that it seemed like that the prosecuting attorneys and the judges, the court system have more or less usurped our rights as pettit jurors. And if they find out when you're called for jury duty that you fulfill a fully informed jury member or believe in the rights of jurors, they're going to kick you off that jury in a New York minute and not even let you serve. So the only way you can get out of jury to serve is to lie to them. And I was curious what your thoughts are on any way that, we the people can turn back that clock or prevent them from continuing on down this trail they're on right now.
Okay, Paul, we'll get him an answer to that. Rob, what do you think?
Okay, good question. The right to trial by jury is technically not what the founders would have called a right. They would have called it a privilege. The right is the right not to be incarcerated, if you're innocent, and the right to a trial. The jury is the Anglo-American, the English-American way of protecting that natural right. And Paul is correct to say that part of the rule, of the traditional rules of the Anglo-American jury, is that jurors can refuse to convict someone who is technically guilty. They don't use that power very much, but they do have that authority. Somebody could be technically guilty, but maybe the victim of overreaching, or maybe the law is grossly unjust, or maybe it's just unjust in this situation. But the jury does have traditionally the right to refuse to convict, and that's actually still the case. So there are folks who argue that they're part of the fully informed jury movement, that jurors ought to be informed that they have the privilege of refusing to convict. Not surprisingly, judges and lawyers don't much care for that provision, and there are only a few states, one is Maryland, that actually have rules in their constitution requiring that the jury be informed of its right not to convict. The answer is the way to handle that would be to run an initiative to change the state constitution to ensure that jurors are informed that in extraordinary circumstances, if they deem the circumstances are extraordinary, they can refuse to convict, even though the evidence points toward guilt.
Okay, we're up against another break. Marilyn and Marlon are both waiting to visit with you, Rob. We'll come right back after this quick timeout. This is the kind of a special edition of Talk Back. The first Tuesday of every month, we visit with Rob Natelson, talking about constitutional questions, and there's never any lack. We'll be right back. Be sure and stop by McDonald's today for 2 Big Macs for just $5 or 2 sausage and egg McMuffins for just $5 at your local Missoula McDonald's. Okay, we're back here on Talkback. 721-1290 is our number, 1-800-568-5309. Rob Natelson joining us from the Independence Institute today in Lakewood, Colorado. We all know now where Lakewood got its name because they just felt like it. So let's get Marilyn on the line. Marilyn, you're on with Rob. Go ahead, please.
Good morning, everybody. Okay, Rob, have you ever heard of the doctrine of the lesser magistrate?
The doctrine of the lesser magistrate?
Uh-huh.
Refresh my recollection.
Okay, well, I think Eric would really like it. Anyways, I have a friend that's just written a book called The Doctrine of the Lesser Magistrates, and I'm not sure if it's actually, well, anyways, what it is it puts, God is the authority, and we're to obey God rather than man, and when man's law goes against God's law, we have a duty and a right and a responsibility to interpose and stand on the side of God's law. And there's a lot of examples throughout history, and
I believe the doctrine originates from a Lutheran confession called the Magdeburg Confession.
Yeah. But
It's
gone
a
before. There were examples of people doing it even prior to that, but yeah, that is a big, huge part of it.
Well, yeah, and there are also plenty of examples in American history. I mean, the civil rights movement is a very good one.
Right. And the pro-life movement.
The pro-life movement's another one.
So what's your question for Rob?
Well, I was just curious if he'd ever heard of it. And
I haven't heard of it by that name. But I've
Okay.
certainly, I mean, it's a constant all through American history. It's a constant through world history. I mean, you've always got a circumstance where man's law is lesser, or rather doesn't match God's law, and then people who see the difference have to make some moral choices. It's one of these issues that recurs to every generation.
Right.
Thanks, Marilyn.
Thank you.
Appreciate the call. And so hold on. There we go. I believe we have Marlon on the line. Marlon, good morning. You're on Talkback with Rob Natelson. Hi.
Shalom.
Hi.
Hey, Rob, I really appreciate your work. And
Can you speak up a bit? I'm having some trouble hearing you.
Go ahead, Marlon.
Oh, I just want to say I really appreciate your work and what you've dedicated your life to, Rob. Can you hear me?
Yes. Go ahead.
And I just have one problem that I see. That's that you're a lawyer. That was supposed to be a joke.
All right.
A lawyer joke? No, but I look at this, our whole founding of our country and the founding documents from just the perspective of average citizen out here, you know. And I come from the premise that our founding fathers were coming from the premise that they just wanted to have their freedom. They just wanted to be able to live a free life without being encumbered by the government, you know, being interfered with. And how I see this is the president is not a person. It's an office that a person fills. And if he's going to be qualified to fill that office, he has some very strict guidelines he has to live by. One's his oath of office, and the other is the Constitution that restrains the people that we vote into office who become the government. And so I don't think it was ever meant for somebody to lie their way into office, and then we're stuck with them. You know, those people weren't that stupid to set it up like that. And where they gave the power was when they said if any form of government becomes destructive of these rights, it is the right of the people to alter or abolish them. And then they went stronger and they said we shouldn't do this for light and transient causes, but when a long train of abuses and usurpations evinces a design to reduce them under absolute despotism, it is their right and it is their duty to remove them from office.
Hey, Marlon, forgive me. Is there a question here? Because we got to move on.
Yeah, I want to get Rob's take on that.
Okay.
The problem is I heard very little of that.
Okay.
Because of the nature of the connection.
Okay, well, but basically he was reciting a part of the Declaration of Independence.
Yeah.
Where he talks about if the rule becomes so egregious that it's the responsibility of the people to rise up and remove it and replace it with something else. And do you I think where he was getting is, do you believe that our society, our governmental structure has gotten to that point where the people simply need to rise up and say enough is enough?
No, I think we need to use the constitutional device that's been given to us, and that's the Article 5 process, which we haven't used. I mean, if Thomas Jefferson, who, by the way, was a lawyer, who wrote those words, if Thomas Jefferson were among us today and we said, hey, you know, we've got all these problems, a huge federal debt, a government that's out of control, he no doubt would look at us and say, well, you know, have you used all the provisions in the Constitution to deal with it? And we would have to say, no, we've never used the Article 5 convention process. And so, and Madison, who was not a lawyer but very well educated in the law, in fact said the same thing, that before you go to revolution, you need to use the processes that are available in the Constitution. I suppose I should say something in defense here of the legal profession. The American founders were, in fact, the leading ones, about 2/3 of the drafters of the Constitution were lawyers, and leading founders who were not at the convention, like John Adams, for example, and Thomas Jefferson, were also lawyers. It is a source of pain to me today that so much of the legal profession is not out there leading the charge once again for constitutional and limited government. But I think it was Edmund Burke, a great British parliamentarian, who pointed out that, very often the lawyers are on the bad side, but if you can get them on your side, they're no better allies to have.
All right. We're going to take a little break, so 1 minute timeout. Alan, if you don't mind holding, we also have one line open. If you want to get in the last few minutes of the program and visit with Rob, have a question or a comment, we'd love to hear from you. It's 721-1290. As always, this time just flies by when we visit with Rob Natelson from the Independence Institute. And so many people want to visit with you, Rob, so let's jump right back into the phones. Alan, you're on with Rob. Go ahead.
Yeah, good morning, Rob.
Hi, Alan. How are you?
Doing good.
How are things in the Bitterroot?
I think it's springtime all of a sudden.
Yeah,
wow.
It is, yeah.
That happens for a week or two every winter in western Montana.
It sure does. Hey, I've got a question a little different. I've been considering and wondering about martial law and what in the Constitution says martial law can be imposed under what circumstances, and who has the authority to impose martial law under the Constitution?
Well, the Constitution actually doesn't contain the terms martial law, and so you have to read the words in the context of the history. Okay.
Well, that's why I was asking the question.
Yeah. As to the actual field of battle, suspending rights and extending military control of the actual field of battle, that is clearly inherent in the president's power as commander-in-chief. So if Alan, you and I are wandering around a battlefield and we're causing problems, then the commanding general, acting on behalf of the president, can take you and me into custody. The Constitution does has one section that deals with a wider situation, where beyond the field of battle for the whole country, and that is that there's a power to suspend the writ of habeas corpus. That is the power to lock up people without trial.
But that's in Article 1, which is a constitution.
Right, and that is the power of Congress. To suspend. It's not the power of the president, except within the field of battle. In other words, the president can respond within the war theater, but for the whole country or for wide parts of the country, that's really up to Congress. But it's an area that the courts have had to struggle with because, as you know, we've been through a number of major wars, and sometimes it's just a matter of coming up with kind of a rule of reason. And it may not be a firm dictate that you can lay down in advance and say, in this case it's okay, in this case it's not.
Well, let's take an example and expand Ferguson and the demonstrations and the rioting and say that becomes nationwide. Has the president got the authority to declare the whole country a battlefield and then declare martial law?
Not unless the whole country is a battlefield. Yeah. It would be up to Congress to suspend the writ of habeas corpus. The president, if he had to deal with issues of insurrection, he would have to, he could suspend habeas corpus, which is similar to imposing martial law, or part of imposing martial law. He could do that where the actual riots occurred. But the Constitution's real clear that otherwise, if you're dealing with issues of insurrection and you need to suspend habeas corpus, that's up to that's up to Congress.
But specifically, Rob, for Missouri, wouldn't that be the governor's job?
Well, yeah, that's it. That's the other part. That's not really the question that Alan asked. He's dealing with, suppose the president had to become involved. But you're right. Under normal circumstances, or even in this case, abnormal circumstances, it's really the responsibility of the state to respond, and the power of the state to impose martial law really depends on the terms of its own constitution.
Right. Hey, Alan, we got to get one more call in.
All right, thank you.
Thanks for the call. And so this would be Mike. Mike, we have 2 minutes. Go.
Hi, thanks for taking my call.
Hi, Mike.
Recently, the Boy Scouts of America lost a $7 million lawsuit. Apparently, 40-some years ago, a boy was abused by a scoutmaster, and I just wanted your guest's opinion on how much responsibility an organization should take on if one of its members commits a crime. And my second question was if he could change the Constitution by a constitutional amendment, how would he do? What would he either take away or add?
Okay, so real quickly, Rob, you got 2 minutes. Go.
Well, I can't comment on a particular Boy Scout case. I'm a former Scout myself, and I have great admiration for the organization. Obviously, there is some duty that the Boy Scouts have to screen its leaders to make sure, for example, its leaders are not pedophiles. But how you apply the duty to a particular case that I haven't studied, I just can't say. As to what amendment I would like to see, I think it probably would be advisable to impose one or more amendments that would push us back toward founding era principles. Clearly, something has got to be done about the fiscal situation. Congress has been promising to balance its budget for many years, but they've balanced it only 5 times in the last 55 years, I think the figure is. One amendment that interests me, and I'm not necessarily endorsing it, is an amendment called the National Debt Relief Amendment, which basically says that if Congress wants to raise the debt limit, they can do that, but they first have to get the approval of the majority of the state legislatures. That adds an additional check and balance there. It provides flexibility in case they have to run a deficit, but it provides an additional constraint on Congress's spending power. Obviously, they're not going to balance the budget anytime soon on their own.
We have 30 seconds, so tell us how we can get a hold of more information about Rob Natelson and your work.
Well, the 2 things. One is the best thing to do. 2 best things to do. One is to check out the website at constitution.i2i.org. That's constitution. The letter I, the number 2, the letter I.org. You can read the stuff we talked about today. One little bit of bragging. My work on the necessary and proper clause was cited this past year by Justice Thomas in one of his opinions. So it's gotten a significant amount of recognition.
And we are out of time, Rob.
And that's it.
Thank you so much. It's always a pleasure. See you tomorrow.